Welcome today to Can You Get Your 301 China Duty Back? This is presented today by the Foreign Trade Association, sponsored by Sue's firm, MSK. And we want to thank everyone today for joining us. I see we have a few extra folk in the waiting room that have just come late, so we're going to let you in. And thank you for attending today's seminar. Seminar will be focused on addressing a number of issues that have been presented by this new this new case, HMTX Industries, and all of the issues that have flowed from it with respect to List 3 and List 4A. And so without further ado, let's see if we can get there's our next, everybody can see hopefully the agenda now. This list 3A and 4A and exclusions, kind of an overview. The HMTX case, the role of the Court of International Trade, possible outcomes that are expected from the litigation, to protest or not to protest, next steps and questions. So why don't we, with no further ado, why don't we, Sue, while I've done some of the talking, why don't you take over today, because we're co-presenters on today's presentation.
Thanks, Cameron. So look, everybody has heard about these cases. There's a lot of confusion to some extent. There's a lot of angst. There's a lot of what the heck is going to happen. And truthfully, this is still very early in the process. So what we're going to try to do is give you some of the highlights, see if we can preview some of the issues. But this is not going to be something that's going to happen quickly. And we'll talk a little bit about that in more detail as we go along. But to start with, you'll notice that we're talking only about lists 3 and 4A. And there's a couple of reasons for that. And part of it will become evident as we talk about the case itself, and that is the HMTX case. But this does go back to 2018 with the publication of lists 3, followed subsequently in August of 19 by the publication of list 4 that got split into 4A and 4B. And you're not really going to hear any discussion at all about 4B because at this point, as we all know, those tariffs have been suspended and they're not being collected, so there's no real ground to seek any kind of action on it. Whether that changes in the future, of course, remains to be seen. This is just to touch on the last point quickly on this slide. This is one of a number of efforts by the current administration to exercise trade remedies under US law. We could spend the next hour and a half talking about the exclusion process and how delightful it is to work with, or not as the case may be. I think the relevant point to make at this stage, however, is at least for right now, the exclusions all expire at the end of this year. And there's a lot of speculation about will they be extended? Is Lighthizer comment about everybody had enough time to get out of China, don't bother me, really going to be the standard? And obviously where this all goes may well be influenced, at least in large measure, by what happens with the election. Cameron, why don't we go to the next slide?
Sure. And before we leave this, I just want to say that each one of these links here that you'll see on the slide, and we'll be providing the PowerPoint presentation in a PDF format after the conclusion of today's meeting to all of the attendees. This will take you to the USTR websites or to the customs websites where you can find additional information on each one of these. And so if you do see hyperlinks as they're presented throughout the slideshow, you'll see those for additional information and research to the extent anybody would like to drill down into these issues. Let's see.
Technology is getting the better of us today.
Indeed. Here it is. Oh,
okay.
Where's now it went too fast. There it goes. The HMTX case. So really the genesis of this case, for those of you who haven't been paying attention to the trade press, is that a large importer HMTX, and its counsel, Aiken and Gump, prepared and filed a lawsuit. And that lawsuit was filed in the Court of International Trade and made a number of allegations. Sue, why don't you address some of the allegations in the complaint?
Okay. So as Cameron said, the lawsuit got filed, and keep in mind that the Court of International Trade does not have the ability to deal with class action cases. So what we're really seeing is just what the lawyers politely call a plethora of these cases. But essentially what HMTX argued was two things, and this is why it's lists 3 and 4 only. The first one was that under the 301 laws and regulations, USTR only had a limited amount of time in which to impose the tariffs. It's actually a year from when their investigation ended. And because the tariffs on lists 1 and 2 were imposed within that 1-year period, there was really no ground on which to challenge those. But lists 3 and 4 came significantly after the 1-year period was over. And so on that basis alone, there was a ground for challenge. But then secondarily, what the case says is 301 is designed to allow the U.S. to seek first to work with a country, and failing that, to retaliate against a country's practices, in this case that dealt with intellectual property rights. And when you read the press, whether it's Twitter or the real press, very clearly lists 3 and 4 were not tied to China's intellectual property rights practices, but rather were tied to China's retaliation for U.S. action in imposing the tariffs on lists 1 and 2, and then subsequently 3 and 4. There was a step taken by USTR sort of in the midst of all of this, where they tried to argue that all they're really doing is amending their earlier action, and HMTX has basically said rubbish. The relevant executive order has been cited here, and to this point, the last thing I saw was that there were 3,841 lawsuits and something in excess of 350 lawyers/law firms involved, and probably well over 4,000 importers, because we have at least one case, I know others have other cases, where you have, as did happen with HMTX, multiple plaintiffs. And so although HMTX is the phrase or the name that you'll hear, just in that lawsuit alone, there were 4 plaintiffs. And that lawsuit initially only challenged list 3. And then as things began to jockey around, it was amended to also add list 4A. Cameron, let's go to the next slide if we could, please.
Well, before we do that, I also want to just touch on the fact that the publication date, which we'll discuss in a little bit more detail on the next slide, of the original executive order triggered somewhat of the first wave of news flashes, if you will, about what's the proper date in which one can file a lawsuit and have made it to the courthouse steps in a timely fashion.
Right.
So we have a lot of conjecture about that we'll address on the next one, but certainly the executive order is the underpinning of this lawsuit and certainly looks to be the trigger date as to whether or not there is a timely filing. And just to continue on with that theme, the first date that was, shall we say, broadly known to folks would be the date where we're talking about the 18th of September. And many people filed on that date because it was the Friday before, and, you know, gave people a certain degree of latitude within the filing process. I think certainly perhaps smart lawyering and the high holy holidays and a few other miscellaneous factors worked into why people recommended filing on the 18th. The next available date would be the following Monday. And then we have also the 24th of September, which was thought to be the date, or is the date, that Customs first assessed a duty on any importer who would have paid it in or around 2018. And as a result, the 2-year date ran from the date where the harm arose, or somebody actually, you know, can say, I was damaged because I had to write a check that I wouldn't have otherwise had to write.
And we're seeing, and we'll talk a little bit more about this when we get to discussing the two likely first round challenges or points that the Department of Justice will raise on behalf of the government. But there are also some lawsuits that have been filed after the 24th that actually make the argument that Cameron is making right now, which is, listen, I don't care when the thing was announced. My cause of action doesn't arise until I've actually had to pay the tariff. And there's a lot of conjecture about which one is going to rule. I think the interesting question for purposes of this slide is the court clearly has jurisdiction over trade-related issues. The question is whether you can get into court on this particular topic without having to file a protest. The lawyers shorthand this as 1581A or I. 1581, of course, is the provision in the law that addresses the jurisdiction of the court. We all know that typically the way you get into court, at least before the CIT, is you raise an issue by way of a protest, Customs denies it, you pay whatever's owed, and then you take that matter to court. Because of the nature of the claims that were made, and we'll talk again a little bit about some of those in more detail in a bit, but because of the nature of the claims that were made, the argument that is being made in all of these cases is you don't have to go to Customs, you don't have to get a denied protest, and you can simply get into court invoking I jurisdiction, which is a shorthand way of saying it's a catch-all. In other words, there are other provisions between A and H that dictate certain kinds of cases, and when you have a case like this that doesn't fall within any of those, it's I jurisdiction. We know that's one of the first things that's going to get challenged, and we'll talk about it a little bit more. But what's going on in the background right now, because it's still very early on, and most of you don't, I know there's a couple of lawyers on the session with us today, but most of you may not be aware that once the lawsuit is initiated, of course it gets served on the other side, and the government has 60 days to respond. So the earliest the government's going to have to respond is going to be sometime probably right around Thanksgiving. So the first thing that the Department of Justice jumped in with was to file in the...
Can everybody mute their...
Yeah, please.
찍었어요. 카톡 보낼게요.
All right, somebody's going to need to mute their line.
보낼게요. 네. 네. 네.
Let me try to mute our participants one moment.
Yeah, I know who it is because I can see a mic on.
Right, I'm going to mute all. But then I'm going to go down to you.
We're unmuted. Yeah, we're good.
Okay, so you're unmuted. All right, I muted everybody now.
Okay.
Thank you, everybody. If you'd please try to note that if you're not muted, we can all hear what you're saying. Thank you.
So the first thing the Department of Justice did was it filed in the HMTX case a request that the court basically set a way in which to manage these cases and recommended a series of things that included that there be what is called a steering committee amongst the plaintiffs' bar. So some degree of jockeying on who should be on that, but that's not to be surprised. It's not surprising. The plaintiffs' bar came in and said, yeah, we agree there needs to be some form of case management. We think that's a good idea. There's some question about who should be on that steering committee. But also, instead of all of the cases being assigned to one judge, as the Department of Justice had suggested, the request was that it be submitted to a 3-judge panel. Now, you can imagine trying to manage 3,800 cases on your own, so I'm going to guess, but it's pure conjecture at this point, that the 3-judge panel is probably what's going to be adopted. And so where we're at right now is waiting to see what the court's going to do for case management purposes. And then sort of from there moving forward, the expectation, I think, is that certainly the HMTX case will be one of a handful of cases that will be selected to be the sort of lead or test cases, if you will, to use the parlance of the CIT, where those cases will be hard fought to the bitter end, so to speak. And then the outcome of those cases will dictate what happens with everybody else's. Cameron, did you want to add anything or should we move on?
No, well, other than to say that, you know, although there are these 3,800 cases, I think substantively, given the nature of what's happened here, is that most of these cases are, in terms of the arguments presented by the attorneys and the legal issues raised, are more or less identical. So
Yeah.
This approach makes sense because everybody who is within this, should we say, sphere is similarly situated. They're all looking to address the same basic facts in terms of what did the government do wrong that would cause this duty to be improperly assessed and therefore refundable because it was not legal to begin with. And at the same time, despite their nuances of who paid how much and what your classification was, all of those issues are somewhat secondary to the prime issue, which is, was the list 3 and list 4A process proper and legal? And can we address that in an efficient manner? And that gets really to this notion of, as you say, the leader test case. Because at the end of the day, it's an agency of the United States government, and it's assessed these fees either, if you look at the USTR, and that's one of the things we'll talk about with respect to the protest, is, you know, who is being the actor, who is assessing these, and who is simply doing the administrative actions of the other. And this is an important but, you know, somewhat subtle distinction in terms of who's paying and who is collecting and who passed the rule that is the basis for the collection. That's really the three things that are at issue here, and whether the whole process was legitimate from the beginning.
Yeah.
So let's hope my computer acts a little faster here. We'll get to the next slide.
I'll tell you what, you
There we go.
Okay.
Possible outcomes. It's you have to attempt it a little bit, all I can tell you.
So talking about possible outcomes, it is almost a matter of routine that the government will file some kind of a motion to dismiss most cases if there's any ability to do so. And oftentimes the government has to get to pretty extreme means to find something to object to. This is going to be a little bit more straightforward because, first of all, there's the statute of limitations question. This is the issue about when does the 2 years expire. So Cameron ran down these dates, but let me kind of go through them quickly because there is some relevance to each of them. The first one was the 18th. Well, the 18th was the day on which USTR announced by way of a press release that the tariffs would be imposed. And I think there's relatively uniform agreement that a press release doesn't confer any legal benefits or legal duties or legal harm. And so the 18th as the date is probably not the key. And again, we're not going to know until the courts rule on this, but the general thinking, I think, is as follows. It's not the 18th, it's the 21st. And it's the 21st of September because that's 2 years from the date on which the executive order was issued. And under what I referred to earlier as the 1581I jurisdiction, it is 2 years.
Correct.
The way in which the executive order was issued was one thing. It was closely followed in many ways by the Federal Register notice, which was actually also issued on the 21st. And it clearly did not impose the 301 duties on list 3 until the 24th. So the first question the court's going to have to deal with, is it the date of the Federal Register notice, or is it the date of when the duty was imposed? There is then this secondary question, and this is where there's something of a bright line with some of these cases. And that secondary question is, what happens if you didn't actually have an import until, let me just make up a date, September 30th. So you weren't harmed by the duty, this 301 tariff, because you didn't have to pay it until you made your entry on the 30th. Is that the date on which the statute of limitations starts? Or is it based upon the Federal Register notice? So that's going to be one issue where there's probably maybe 3 or 4 categories of folks There's going to be those who filed the 21st or earlier, those who filed on the 24th or earlier, so the 22nd, 23rd, 24th, and those who filed on the 25th or later. And then the second issue goes back to the one I was just talking about, which is there was no protest filed. The argument that this case makes, although it doesn't state it directly, it's certainly inferred, which is Customs administers the law on behalf of USTR and has no discretion here. USTR having enacted this through the Federal Register, Customs simply has to collect and enforce. And so that's going to be the second issue that we expect to be briefed initially. And whereas the statute of limitations question typically has to be raised first or at the earliest opportunity, this protest, no protest issue is sort of the guts of what's going to happen. Now, everybody wants to know if it's successful, when are you going to get your money back? And the answer is it's going to take years. Because if we assume the best possible outcome from the importing community side, it is that once the CIT proceedings are over with, that the importer wins, or that the importers win. And assuming that that happens, you can bet the last penny in your wallet that the government's going to appeal. And it will go to the Court of Appeals for the Federal Circuit. Now, it's a separate court. They're going to look at the record. If the government wins there, the question will be if the importing community wants to appeal, and the appeal from there is to the U.S. Supreme Court. It is also possible that this case won't go on very long because either the statute of limitations issue will knock out a lot of folks, or arguably the court could say, I don't think they will, but they could say, look, you could have raised this on by way of a protest. Yeah, even if you want to say that the government, the Customs had no discretion here, you still could have raised this 2 years ago. So we just have to see how this plays itself out. But one of the other questions that has a lot of people talking is if you assume for purposes of discussion that the plaintiff's cases win, the next question becomes, how is that money refunded? In other words, the court clearly has the ability or the jurisdiction or the authorization, whichever word you want to use, to make a decision that says these tariffs are illegal from the outset and all the money that was paid should be refunded. Now, there is at least some doubt about whether the court would go that far, or some question about whether the court would go that far, and we'll come back to that in a minute. But if we assume the court goes that far, it's still a question of, as we've seen in other cases, would the refunds only be issued to the plaintiffs who brought the lawsuits? Would the refunds be issued to all importers? Do you have to file a protest in order to get a refund? And how far back can you go to do that? And we know that that's 180 days from date of liquidation. And how in the world is Customs ever going to administer this? Now, you know, it's true that Customs has all of these entry records, and it's not that difficult for them to do a sort by the various Chapter 99 provisions and start refunding the money. But if we're lucky enough that that's the outcome, importers need to make sure that they're keeping track of all of their entries on which they think they're entitled to a refund and making sure they get those monies. And we'll talk about that when we get to next steps. Cameron, did you want to add anything?
Yeah, I do think that the burden will be on the importers ultimately to prove their damages, as it would be in any law, in any legal action. And just like in a protest, or frankly, any action against Customs, the burden always falls on the importer to prove its side of the case. Customs is very comfortable with telling you that you're not entitled to whatever it is you think you're entitled to, and will not give you a lot of reasoning as to why unless they absolutely have to as a matter of law. So I think that everybody who's on this call, and we'll talk again at the end of this as the next steps, but is reminded that, you know, although you only have to keep these records for a period of 5 years under the statute, you're going to need to keep these records for a very long time, because you may need these records. And by these records, I mean the commercial invoices, packing list, 7501, and any other documents that were in support of your claim at the time. Because even though you may have filed, and I have a client that recently has learned this the hard way. They classified the goods in a particular way, thinking that the classification was correct. They thought that they had an exclusion based on that classification, mostly because they had gone to the USTR and asked for an exclusion and been granted one based on that HTS code. After the protest was timely filed, they were informed by customs that they had in fact not classified it correctly, and therefore the protest was denied. There's a much longer and much more complicated story than that, but what I would encourage everyone to do is make sure you understand why you classified it the way you classified it, and have all the documents in support of that classification, because if the classification were to change for some reason, and of course classifications do change over time, and you need to understand that, you know, this is a moment in time issue. So was it properly classified at that time that it was entered, and can you prove it, and how do you prove it? And that means having numerous pieces of paper and the cooperation and the coordination between you as the importer and your broker to make sure all of these records are preserved. Well, we get on to the next slide, which brings us to protest or not to protest, which has been quite a robust debate. A lot of people throwing in various commentary about whether to do it. I can share with you all that I was on a call with various members of the broker community, various members of the legal community, and in both camps, the only consensus that I can share is that there is very little consensus.
Yeah.
I think as the process goes through and people write more articles and post more thoughts about why they think it is proper to protest or not to protest, camps will inevitably form. And these camps will be based on sound legal reasoning, and they will each have their own views. And there will always be, you know, shall we say, the majority view and a minority view. And this is true in almost any legal question that gets thrown out there. So I think the safest course of action that we can draw from this is you have to look very carefully at your individual situation and make a very considered business decision about whether or not you should or should not protest. And you should also talk to your legal counsel and your broker about what their views on this, your particular situation are, and whether it makes sense. I will say that I will encourage anyone who has a granted exclusion to utilize that granted exclusion, or who believes that their goods fall within the scope of a granted exclusion. Do not stop looking to recover those duties using a PSC or a protest, depending on the timeline in which you're inserting yourself. Because obviously you need to make sure that you're doing that, and you need to make sure that you're doing it in the right way. Like, don't file the PSC late, leave it alone, and then below the protest period, thinking that you filed the PSC properly, and then come back to it only to realize that you've blown both. That has happened. People have filed protests incorrectly. They were not properly uploaded. It requires some due diligence on the part of the filer to make sure that you're following it to ground, making sure that your protest is before customs, and that you're getting your money back. And for if no other reason, if you can get your money back today or within a reasonable amount of time, 30, 40, 60 days, and maybe a little bit longer, depending on how customs is rolling with the refunds, you should file that protest or PSC now, because you'll get the money now. You could wait a very long time if you do not do that to get those monies. Now, go ahead, Sue.
No, finish your thought. Go ahead.
I just want to say now that does not really address, though, other cases where there is no granted exclusion and no hope of a granted exclusion. And that's a separate conversation to which we've been talking about whether to protest or not to protest.
So in the category of protest or not protest, I think this falls into two camps, just to make it easy. The first camp is, I filed a lawsuit, and there has been a request by the plaintiff's bar that the government enter into a stipulation, which, as you all know, is just an agreement between the parties, that if you filed a lawsuit, you should not have to file protests, that the lawsuit itself should be enough. The government hasn't yet agreed to that. And of course, there is some history. The one that everybody looks to is, of course, what happened with the harbor maintenance tax, where there was a lot of agreement to do certain things. That did raise some constitutional questions. The harbor maintenance tax really turned on the question of whether that fee or tax was a tax on exports, and ultimately was found that it was. This is a little different a situation. This is a situation where the court is being asked to interpret a statute and determine whether or not the agency, in this case USTR, exercised its discretion within the bounds of that particular regulation or statute. So there's this whole question about, will the government agree? Now, the flip side to that is, if the government doesn't agree, it's going to get even more protests than it's likely to get otherwise. Again, admitting that the court has the ability, the authorization, the jurisdiction, again, whichever word you want to use, to go and say that this 301 tariff on list 3 and on list 4A is, as it gets called, well, let me just put it this way, that it's void from the beginning. That's the easy way to describe it. If it's void from the beginning, then all the monies should be refunded. If that's not where the court goes, and you haven't filed a protest, you may not be able to get any money back. And again, not to sound too much like a lawyer, excuse me, but this is one topic where sounding like a lawyer is really required. So you heard me say early on that these cases, this HMTX and the other ones, fall under what's called 1581I, which is just an other jurisdictional kind of thing. If you're going to file a protest, you have to file it under 1581A. And in order to file a protest, you have to be able to find something that the government did. And in this case, the government is not USTR, it is CBP. So if you're going to file protests out of an abundance of caution, make sure that you talk to a lawyer. This is not something, as good as the brokers are, they are not lawyers. And this is not an area that they should be dabbling in. So when we say belt and suspenders on this particular slide, what we're saying to you is, until these cases move further along and we begin to understand what the government is going to agree or not agree to, and what Customs is finally going to try to get the Department of Justice and USTR to agree to, given the unbelievably large volume of protests that are expected, you want to make sure that you've talked through the issues, as Cameron has said, with your legal advisors. And you also have to do a little bit of weighing here, because the protest period is 180 days. If you don't raise the issue within the protest period, you can't raise it later. So if you have an exclusion you want, and you want the 301 refund, and you want an even greater refund, for example, because the classification is wrong or the value is wrong, you have to think about, if you raise all of that in one protest, how long is it going to take for you to get your money back? And are you willing to run the risk of waiving your right to get the 301 list 3 and 4A monies back if the case is successful, versus getting your money for the exclusion or the change in classification or whatever the other ground for the protest might be in hand? Now, I have to tease Cameron here a little bit, because I don't know any protest that's being granted in less than a year, unless you're all over Customs and they can find somebody to work them. And that is another problem. The Customs is already overwhelmed with these claims, whether they're exclusions or otherwise. And so if they're going to now start to get hundreds of thousands of protests, it's going to be staggering in terms of bringing the agency to its knees. So this is one of those topics where, certainly from a case management perspective, you would hope that the government is going to say nobody needs to protest, but we can't rely on that.
And all I can say is maybe my ability to pull the jackpot every once in a while got lucky on the timeline, but as I say, maybe just lucky as opposed to what is typically happening. And I can certainly appreciate that more and more protests have been filed in the last 6 months than at the beginning of the process, where we, I think, saw a fairly reasonable turn time. I think we can expect there to be increased delays. The current distraction of COVID has, and that's putting it mildly, has caused everyone to, put on their patience hat. I can tell you that getting a hold of people at customs, and certainly I think anybody who is dealing with customs on a regular basis can echo the fact that getting people on the phone is taking longer. Everything is taking longer. And so the time horizon, even on properly filed PSCs, protests, and whatnot, getting any sort of answer is going to be a continuing, in a timely manner, is going to be a very challenging environment for everybody to work in. And not to mention what's going to happen here in November in the lame duck Congress, or potentially lame duck president, depending on how the election comes out. I think all of these factors have to be weighed by individual importers in determining what makes the most sense from a business perspective and what makes the most sense based on your individual situation and whether the exclusions can be reasonably relied upon. Because if you don't know that that's your HTS and you filed, for example, previously, and we've seen many cases of this where the importer, and it wouldn't be necessarily a big change in classification, a minor change, thought it was classifiable under XYZ. In fact, it was maybe 2 digits over and should have been classified in that second classification. So you have to write your protest to explain first why you should have classified it under the HTS is different from how you filed it. Then you have to explain why it falls within the exclusion. And then you have to request for the money back if you're writing that particular kind of protest. So it, as Sue alluded to, the protests, the longer they get, the more complicated they get, the more fact intensive they get, the longer it will take to process them. And frankly, I think a lot of import managers have gone from, working on the import side of the desk to filing nothing but protests pretty much nonstop. At least that's what I've heard from a number of my clients.
Yeah, I think that's true. But look, the other issue that we should just touch on, since you brought up the election, is one of the questions I keep getting is, so assuming that Biden is elected, how quickly are these tariffs going away? And I don't want to have a political conversation, but I'm going to tell you that I don't think they're going away anytime soon. And I say that for a couple of reasons. First of all, because there are so many other significant issues, starting with how the virus is proceeding, that are going to occupy this administration, that alone puts this issue further down. But the other thing, the other primary reason that I think that these tariffs are going to stick around for a while is they're really popular with both Republicans and Democrats. And they're really popular because nobody has a better answer for how to deal with China. So to the extent that I'm hearing anything useful out of the Biden campaign, there is at least some possibility that exclusions might be reactivated, that they might become more objective, that there might be some reasoning provided so that they would be more precedential in nature. But we're just going to have to wait and see how that all plays itself out. We'll go to the next one.
I just did.
You did, yes, please, go ahead.
Yeah, and I would agree that as this evolves in phases, I think that you will, and whether you're talking about the duties being assessed in phases, and we're obviously seeing the administration now tackling additional 301s in other geographic spaces like Vietnam. You're going to see Those investigations are going to be taking a lot of time. You're going to see a lot of time and effort has to be put into the de-escalation, if you will, of this. And then there's going to be the question about, you know, why and how does this affect our relationship with China? So there's a lot of balls in the air, as you pointed out. And I think regardless of which administration tackles 2021, this is going to be an issue that will be persistent in our environment. It seems that's the case because, frankly, if we were going to be seeing anything, at least from the Trump administration, I think we'd be seeing an increase in you know, duties being assessed potentially even on the de minimis and on other areas. So there's an appetite for protectionism on both sides of the aisle, and there's an appetite for assessment of duties because, if nothing else, the catastrophe to the global economy that was predicted didn't really happen as a result of these tariffs. You can say a lot of things did happen because of these tariffs, but not necessarily the global loss of GDP that was anticipated. That was really more as a result of COVID, I think, as being causationally related. But again, we want to keep on to the slides and the focus of this, rather than, I'll sort of say, crystal balling what's going to happen in November. So next steps, again, tracking your entries, tracking your merchandise. How is your merchandise being classified? Does it fall within list 3 and 4A? Many people called and talked to our office who said, I want to get my duty back, but most, if not the vast majority of their goods fell under list 1 and list 2. And to be clear, those aren't on the table right now. So you really want to focus on tracking all of the 301 list 3 and 4A tariffs paid. And I also want to mention that, keep in mind that the upside potential here is not limited to just the duty, but there's the potential to recover interest on that duty as well. So don't forget to calculate that in, as well as the duties that you've paid in the past, but will pay in the future, because this is going to go on, as I think Sue and I have agreed, that it's going to go on for the foreseeable future. So don't think that the story is over in terms of your total economic harm as of the date that you filed the lawsuit. It's an ongoing harm, and you want to have an accurate calculation of all of your duties paid and the interest thereon.
Yeah, I agree with you. I think that you know, the more you can track this, the more you stay informed, the better off you are. Why don't you go through the rest of the list, and then I'll add a couple of things.
Sure. Again, you can get your broker, or you can go on through ACE, and you should have a list of all entries where the tariffs that were assessed on list 3 and 4As were paid, and the relevant details. And you want to regularly update that list so that you know where you're at from a financial point of view. You know, this is certainly not necessarily at the CFO level, the people in the import department. Certainly you can use the assistance of your broker. You can certainly look to ACE, and there are a number of reports that you can run in ACE that may be of value to you in gathering these. At the same time, scanning the documents, and many businesses that I have as clients, you know, they work on a different basis than customs does. You need to, in this process, it's very important to file and keep records on an entry by entry basis, because that's what customs cares about. And that's how you're going to be best able to assist your lawyer and best able to get your refund should that opportunity present itself. You want to have these files kept on an indefinite basis, and you want to keep them in a place where you're not going to lose them readily. So be mindful of the problems that we've seen in the news on a, you know, as recently as this week. I understand CMA CGM finally got control over some of its data that was being held hostage. So know that if it can happen to them, it can happen to you. You want to have cloud backup, you want to have server backup, and make sure that you can control your data and don't lose that data that you may have worked so hard to create and to store. And you also want to have your customs broker keep their entry files on an indefinite basis as they affect this. Because your broker is going to have software that will help you stay organized, will help you keep your record keeping on an entry by entry basis. They're a good source of information, and you want to, utilize that for record keeping purposes, and know that almost any importer, unless you make a specific written request, those documents will be very customarily, as it's how brokers don't have an indefinite amount of storage, will eventually put those records into some form of, harder to get to place than you might think. They might just destroy them altogether and outright. I mean, in the old days, we would take them and put them out with a box for the guy with a shredding machine to come pick up, and there was nothing else to be done about it. And that's the way it worked. Today, we're a little more complicated than that, but I can tell you, archiving doesn't mean you can find it. It means it was archived, and maybe it's there, maybe it's not. No disrespect intended to the IT folk, but I just went back for a client to find something that was done in 2008, and there was very little to be found, to be honest. That was it. It took hours and hours to find.
Part of the reason for that, though, is that what happens is you gather the data, you save the data, you mark the data, you deal with all the data in one software program. And then there's a transition to another program. And because it's an old record, nobody goes back to make sure that that record that you transitioned actually is still legible or usable or retrievable. And so having that data as close to Outlook, to the extent that that's the email program that you use, that whatever those regular programs are, I mean, that's really what you're looking to do in terms of keeping the data, and making sure that you've gone to your broker, as Cameron said, and asked them to keep the files. Now, I think we have to be honest and say to everybody, if you're asking your broker to do things like help you file protests, keep these records, do not be surprised if they don't want to charge you for it. This is something what we're seeing that they actually are, and you need to be prepared to compensate them reasonably for the fact that you're asking them to keep these records for a longer period of time. Now, some brokers are more sophisticated than others. They scan everything. They've got everything electronic. If that's the case, then you can do a data dump, and the recommendation is you do that sooner rather than later. We are in the process right now of dealing with an exclusion for a client, and I went to the broker and I said, I'd like to get what we, in the old days, used to call a liquidation report. So it's a report that tells me entry number, date of entry, a whole bunch of data about the entry itself, including information at the line level. So value, classification, collection at that line level, harbor maintenance tax, MPF, and so on. And what I got from the broker is next to useless, because their system doesn't store it. Now, I will tell you internally, I went to one of my colleagues and I said, I'm really surprised that they didn't give us an ACE report. But even if you get the customs report, we're still hearing stories. I don't know, Cameron, if you've run the same thing, but we're still hearing stories from importers who say, look, I'm looking at an entry, a record that I've got, and I've got entries that don't show up on customs report. Or I've got entries on customs report that I don't have on mine. Now, the latter one can happen because if your IRS number and POA and other things aren't properly controlled, other people may get that data and make entry in your name that you don't know about. But that's a whole other discussion, some of which may not be quite as nefarious as it sounds. But
you bring up a really good point right there, by the way, because many times people may or may not have a direct relationship with their broker. They may work through a freight forwarder. They may be using multiple wholesale, in quotes, customs brokers. So for any of the importers that are on this call, if you're working in that way, this is a good time to have a direct relationship with the customs broker, because of the nature of the data set is different than what your forwarder may be familiar with. And they may be, again, as you point out, have two different systems, and there needs to be closer coordination. And to your point about the EIN, if you have a company that is merged or acquired or something changes where the EIN number changes, you need to know that your importer of record ID number now may be changing. In fact, it's very likely that it will, and you'll be starting a whole new data set. So you want to make sure that you're tracking your company, what your company does, how it does it, how the, and these historical documents from, let's just say, a company acquiring a new company. One of the new questions you want to ask yourself in the M&A space is, do you have any company names that you imported on during this time frame? Because those are dollars that can easily fall off the table if you don't know the questions to ask.
Exactly.
So you want to go back and think about those things, so to capture that as part of your representations and warranty statement within a typical buy-sell agreement for mergers and acquisitions, which there's that. But again, I want to leave some time here because we're running up to the end of our hour here today. I don't see any questions in the group chat question box.
I actually have one that somebody sent me privately, so let me share it with you, because I think it's a good one to start with. And it reads this way: if a protest is filed, is a list of entries sufficient? Or do you think a transactional report to identify the entry summary lines that are affected is needed? I'm of the opinion the easier you can make it for customs to figure it out, the faster they're going to refund the money.
I agree.
I would opt for give them as much detail as you can so that they can easily figure out what you're owed.
Absolutely. In fact, you want to perhaps provide an Excel spreadsheet summarizing your claim, the dollar amount, and the page and line item number that you're referring to if there's entries that are not, one-liners. 100%. The people, the harder you make it for anybody in the government to process your claim, the longer you will wait.
The other thing I would add, and I know we've got at least a couple of our legal colleagues on this call, but I'm still of the opinion that I would not just dump every entry that I have an issue on into one protest. Because if there's some question about any one of those entries, it'll hold everything up. So in the old days when customs had to go retrieve paper, certainly my rule of thumb was never put more than 10 entries or so on a protest. You may want to think about a larger number now, but I think that that's a question. So I have two other questions that I've seen. One George sent to both of us, and the other one is, which said privately to me, says, what is the deadline to file the lawsuit for List 4A? And the answer to that is it's August of 2021. I don't remember the exact date in August, but it's early in the year. However, the List 4A has, of course, as I said, already been covered. So if you haven't filed and you're just on List 4A, you have some time. Although, frankly, I'd get in now, because if you come to the party late, you won't be able to influence what happens. And so, unless you wanted to add anything on that, George's question to everybody was, CBP normally requires the PDF file document for the protest. Can we avoid that? I don't know how you support the protest without giving them everything they want. So if you had something specific in mind, I would say probably not, but I'm open to further questions, George.
Let me see if I can unmute him here.
Yeah.
There
you are.
Okay, good. Yeah, I mean that's the primary issue with the problem with filing protests, right? It's easy to file an electronic protest in which you have a list of all of the entries and the line items for which you paid the 301 duties. And that's relatively simple to do. But if customs is going to say, in order for the protest, for us to accept your protest, you're going to have to file each entry as a PDF document. Now we're really talking about a tremendous amount of work on the part of importers, on the part of brokers, or on the part of the trade firms, because almost every entry is going to have to be PDF'd to customs on its DIS system, its document imaging system.
Right. So, George, I don't know what your experience is. Mine has been as follows. If you're doing a post-summary correction, so pre-liquidation, then they absolutely insist on a corrected entry. And there's just, it's going to be difficult to get around.
Right.
But I have not seen them do this in the protest context. Now, what I have seen them do is I will get either an email or a phone call from an import specialist who says, I'm working this protest. Could I have your spreadsheet in Excel format? And obviously, that's not an issue. But then they go and do the actual calculations. I have not seen them demand a corrected entry once you're at
not a corrected entry, but just a copy of the original entry, because as you know, if there's a protest that ultimately gets denied by customs, then there has to be a document that goes to the Court of International Trade to support the denial of that protest. So customs, at least in the normal classification valuation kind of situation, customs always requires that the protesting party provide customs with the entry document, because customs doesn't keep those documents, right? They don't have them. They have an electronic filing, which isn't the same as the, if we can use this terminology, the paper 7501.
So you're not talking about at the protest stage. You're talking about when it's denied and going to court.
No, customs requires that you file the original document, the original entry and invoice. At least that's what my experience has been in filing a protest.
I've not had that experience, not at all.
Okay, so Mike just said, yeah, CBP requires the entry package.
Well, I'm not seeing it. That's all I can tell you.
That would be making life a whole lot better if we didn't have to provide the entry package.
So with the 301 exclusions, that's a different story.
Right.
Those, they're asking for it because they need to see the commercial invoice. And especially when, as I've had happen recently, some of the product does qualify and some of it doesn't. And then you've got to explain why what you're saying does qualify, why it qualifies, with backup technical specs or whatever it may be. So it just depends on what it is that you're protesting, which dictates, I think, what documents you submit. And frankly, some of this is, I think, just intuitive. We all know as experienced practitioners, you want to get the thing processed quickly. You give customs everything you think that they could possibly need, because you want to give them as little excuse as possible to sit on their hands and delay the processing.
Sure, but if you have to file 1,000 PDF documents with customs, that's
a lot of work. I agree.
Yeah.
So before we hang up, I know that Jeff Goodale is on the call with us, and I don't know if Jeff wants to add anything. I don't think I can unmute him, but Cameron, if you could, just in case Jeff, because I know Jeff's involved with this as well, in case he wants to add anything, if you can unmute him, that'd be great.
Let me find him in the list of participants here.
Oh, he just hung up.
Oh, no.
He escaped from us.
Can you hear me?
He heard you were going to call on him, so he ran, right?
I guess. Jeff, are you there?
I'm here. Can you hear me?
Hey, how are
There
you?
he is. There he is.
Hi, everyone. Excellent job in the presentation, Cameron and Susan.
Thank you.
Really nothing to add. You really covered all the bases, and George had some helpful comments as well. You noted earlier in the call that the defendants had filed a motion for case management procedures. When do you think the court may rule on that? Because depending on how the court rules on that motion could affect which case or cases are lead cases or test cases. Or do you think that'll be a ways off before the court rules on that?
If I recall correctly, Jeff, tomorrow is the deadline for
14th.
anybody that, yeah, tomorrow's the 14th, and tomorrow's the deadline for anybody that wants to comment on that. So, look, I think that we're speculating at this point, okay? But I have to think that the court is going to want to make this decision sooner rather than later. Because, if you start thinking, again, as I said earlier, the likelihood of the government having to file is sometime in late November, early December, depending on when they got served. if there isn't some kind of case management in place before then, do you really think they want to serve 3,841 motions to dismiss? So I don't think the government wants to do that. I don't think the court wants to see that. So I can't tell you that it's going to be the early part of November, but I think it's going to be sooner rather than later.
Yeah, I would agree. November 18th would be the 60th day for the earliest of the cases. And that just seems to create a juggernaut for DOJ that they can't possibly look forward to that.
Actually, I'm not sure. It may be even sooner, Cameron, because the HMTX
Oh, you're right.
filed on the 10th.
They filed on the 10th. They did.
Right,
You're
and then they had to serve by certified mail, return receipt requested.
You're right.
So,
they filed the precedent week, which is that triggered the tidal wave on the 18th.
right.
And so the 18th would be the tidal wave date. But even so, I think you're right to say that something to trigger that would have to happen early part of November.
Yeah. So I think the moral to the story, if we can end on this note, is we're very early in the process. There will be a lot of jockeying about what's going to happen, what the procedures are going to be, what the court's going to want to do, what the Department of Justice wants to do. There's a call on Friday amongst the nearly 350 plaintiffs' lawyers to sort of start to all push in the same or pull in the same direction. I don't know which. And so to the extent that you have an interest in what is going on with this issue, almost all the lawyers distribute some kind of alerts or news stories or whatever. Make sure you get on their mailing lists. Keep in contact with your broker. They too also provide information. And then sooner rather than later, talk to both your broker and your lawyer and figure out what you're going to do in terms of protesting. Because even if you haven't filed a lawsuit, as we said earlier, you may be able to benefit from the refunds, but all of this is just up in the air until we really know what the court's what the court's going to do on the process, and B, what the government's going to stipulate to or agree to up front versus what's going to still have to be litigated procedurally. So on that note, I think, Cameron, as always, it's been fun paneling with you. Thanks very much. Thanks to everybody.
Likewise. And we want to thank again the MSK for their generous contribution in sponsoring this program here today. Also, I want to thank the Foreign Trade Association for continuing to put these forums together and allow for people to have good discussions about topics that affect their imports and exports. And we look forward to other Foreign Trade Association events in the upcoming future. I know there's a number of events in the Friday newsletter that you can review, and also the Foreign Trade Association has a membership drive for new members. If you sign up during this quarter, you can get a significant discount. I would encourage anybody on the call here to look to those events pages on the website, Foreign Trade Association, and also to look at the Friday newsletter and to look forward to those up and coming events that we'll have available for members of the FTA and hopefully new members. So look forward to everyone joining. And again, hope that our membership will continue to support these webinars. Thank you everyone for being participants. And with that, we'll sign off. Have a good day.
Everybody take care. Bye-bye.